Welcome to Rebel Chaser. My name is Gail, and today I've got a bunch of short videos that I didn't know where to put anywhere, so I figured I'd put them all together in one video. So, to introduce them, I've got a couple from Judge Hayward. And I think they're both sovereign citizens, but you guys can make that determination. I've got one from Judge Sanders in Washington. Actually, two from Judge Sanders in Washington. I've got one from Referee Metz, one from Judge Prill, one from Judge Fleischer, one from Judge Middleton, and then the last three are three very condescending moms. One from Judge McNally, one from Judge Kirkham, and one with Judge Mertz. And then after that, I've got a really, really cute video that was sent to me by Miss Kinsley. So I'll let you guys watch.
All right. So Miss Ebony Milner is present. Also the Mr. Brown, who's on here on behalf of Federal National Mortgage Association. Mr. Brown, Ms. Milner, is my understanding that this was heard in magistrate court and this is a request for appeal. Is that correct?
Yes, Your Honor. This is a petition for review from a dispossessory judgment. She was a tenant at sufferance post foreclosure.
Okay. All right. So Ms. Milner, tell me what's going on.
Judge, well, this is a case of land rights, tribal law, and treaties.
No, ma'am. No.
And I would just like to say that I'm a tribal member, part of the Cash Box Trust Tribe.
No, ma'am.
Governments.
No, ma'am. We're not doing that.
And American Indian landowner.
No, ma'am. So we're not doing all that. So this is a simple eviction. So you can tell me how much was owed, how much you paid, whether there's anything to that allowed you to stay in the property, or whether there's money owed to you. I don't do the whole trust, tribe, all of that, because that's not what we do.
Well, that's what this is in regards to.
Well, then, ma'am, that's not what we're doing here. I would either have to transfer you to a tribal court, which I don't know of one exists for you, or for superior court, because this involves a foreclosure. Essentially, he bought the house through a foreclosure. You were a tenant in the house at the time, or you owned the house and he bought it under the foreclosure. And then it was whether you get to stay in the house and pay rent or whether you're going to be evicted. Am I clear, Mr. Brown?
Yes, Your Honor. And
right. Because I don't deal with I went to law school for 3 years, have practiced law for over 30 years, have been a judge for over 12 years. I don't do the trust stuff because that's some arcane, esoteric stuff that you all believe that we don't follow here in the judicial system.
I understand. Well, I would also like to say that I'm not here to handle any of my private affairs in the public.
Okay, so I'm not sure what that means. You asked for the appeal.
Yes, and as I was stating, I'm a tribal member, part of the Cash Box Trust Tribe, and also an Indian American landowner. So this case is in regards to trust and tribal land.
So the property, the foreclosure is on a house on tribal land?
Correct.
Which tribe?
I'm sorry?
Which tribe?
The Ebony Milner tribe.
No, sir. I don't know of that tribe, ma'am. So
yes, and all the documentation had been put on file as well.
Okay.
Post foreclosure.
I got all that, but here's the thing. So I'm gonna explain one more time. Whoever's in the background or their Miller tribe, not sure who that is. I'm gonna have to meet them. Because you're the one who's listed on the. You're the one who's listed on this case. So I can't hear from all of that. So here's the thing. Like I said, I've explained to you that if somebody purchases a home through foreclosure, then the people who are who were owners of the home or buying the home have two options. They can leave or they can be treated as tenants in the home. And in this case, it appears that Mr. Brown's client sought to evict you, and now you are asking for a review of that. So, in my role in this court, I can go through the case as if it was never heard in magistrate court. But what I will tell you is, I'm going to ask very specific questions. I'm going to follow the law under the state of Georgia with respect to landlord tenant. And if you're not able to provide me that information, then I'm going to determine that you're not able to prosecute the case in the way that it needs to be, and I'll dismiss it for want of prosecution.
Well, again, American tribal landowner, so
Okay.
those laws
No,
that you
ma'am.
may speak of don't
No,
apply to me.
no. Well, then, okay, I'm going to dismiss your appeal for want of prosecution. The court does not have jurisdiction over American tribal land, nor is there a designation of this property being a tribal land. So at this point, the court is going to dismiss this for want of prosecution. Thank you. All right, next. All right, the next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Delphine Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointing judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right, so
Okay.
Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction with for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for Mr. Widener.
Intended to name me too. So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible, allegedly, for what you are contending happened. But then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
I'm the attorney in fact on behalf of the principal, who is the registered agent. I already
Okay.
submitted the Form 56 upon you over the matter to
Okay,
administration
I
on
don't,
behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee, and Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. I'm going to transfer the case to Superior Court and let them sort it out because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500. And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else involved.
Ms. Turner,
in this executive branch, I do have a right to sue them and anyone else involved.
Is nonsense. None of what you're saying makes sense. None of what, Ms. Turner,
it's federal law.
Ms. Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen, but
no, it's not a sovereign. It's not. I'm not a sovereign citizen.
If those things work, everybody would
don't put that on me. I'm not a sovereign citizen.
Turner, you've made statements that sovereigns use, and so
I have my trust set up, and I'm not a sovereign citizen.
Yes, ma'am.
I am a person working in my trust.
Okay,
not a sovereign citizen.
All right,
that's against the law.
Okay,
I'm not a sovereign citizen. I have my trust set up.
Okay.
In a way that it's working for me, and I have it set up.
Okay.
And that's what I'm working on, my trust.
Okay. All right. So we'll get that order out. Thank you. You're free to go at this time.
Thank you, Your Honor.
The first individual is Nancy Baldwin. Ms. Baldwin, if you could.
Sorry, I was struggling with that. Hi, thank you, Your Honor.
Good morning. Are you interested in the deferral program?
I don't
you
think
did the
so.
deferral in 2019, so I apologize. You actually do not qualify.
Okay.
So let me go ahead and look at your police report, and then I'll give you a chance to tell me your side of the story.
Okay.
Okay. All right, Ms. Baldwin, please go ahead with your side of the story.
Okay. It was a couple of days after Christmas. I was leaving the Fred Meyer's parking lot. I actually have pictures, but I don't know if that's going to help you. I was coming out of the driveway onto, I believe it was 30th, and there was a semi truck turning to come the opposite way. It was a driving school truck, so I think it was a student driver, but he came way out into my lane, so I had to back up. I was backing up. I had to back up even, again, this picture, I even had to go sideways to get, because he was coming clear into my lane. So I was super close to the car on the other side and backing up when the police officer, nice young man, came up behind me and I was backing up. I think he was a little anxious because I was backing up, but he then started blaring his siren and lights at me while I was still backing up. So the semi truck turned in front of me then and went into the parking lot I had come out of. I proceeded down Ocean Beach Highway, turned left into the Chevron because he was signaling me to pull over. And he had said that I missed the sign. There wasn't a sign out. I drove back and looked. It was just this white line where you're supposed to park behind that so that they can track. So you can clearly see I was already backing up when he came upon me. I don't know why he thought I was above that white line. I would have been in the crosswalk.
All right, ma'am. So the situation is that you were so far forward into the pedestrian crosswalk, which is shown by the two white lines, that when the truck tried to turn right, you had to reverse to make room for it because you were so far behind. And then and then after it turned, you once again pulled halfway in. So that was the story of the police officer.
I know.
Your pictures, I don't know if they're timely because I would assume if you're taking pictures while driving, then you should have gotten another citation for using an electronic device while driving.
Nope. I went back and I understand that he thought I was already backing up, but I was not in, I couldn't even get close to the white line. He was making the turn when I came out of the driveway. The officer just didn't see that. He didn't come upon me until I was backing up. I was probably 3 car lengths behind the white line when the officer came up.
Yeah. Okay. So that's not what he was saying. He's saying that he was just watching you in the whole pedestrian crosswalk. So
that's not true.
Okay. Well, unfortunately, it's his story against your story in this situation. Let me look at your criminal history.
Okay.
All right, and it seemed that you had expired insurance too, and he let you off with that one as well.
Oh, I had it. I just gave him the wrong card. It was in my card, and I tried to show him, and he said, "I believe you. I didn't write it." He was a nice guy. I have it. I could have brought it. I had it actually that day, but he said, "I'm good. I know you haven't."
It's interesting because his side of the story was that you started laughing at him and told him that you would see him in court. So it's a very interesting 2 different sides of the story.
Very interesting 2 different sides of the story. What I was hurrying about is when he pulled in behind me, he blocked the driveway to the Chevron and blocked the gas truck in there. Okay. And so, yes. So, yeah. And I did say, where do I sign this now? Because I do want to tell my side of the story to the judge. And he said, you'll get a notice. And I said, okay, perfect.
Right. So you're saying that you weren't in the crosswalk at all, even though he saw you 2 times in the crosswalk?
100%. I wasn't even to the white line to the crosswalk. I was already my car's small, but probably 2 car lengths behind and even over, because the truck driver was so far, made such a wide angle, which
you're behind the white crosswalk. Why do you have to back up for the truck?
Because it was so making such a wide turn. I had to even scoot over. I was probably 3 car lengths I had to back up. It was a driving school truck, so maybe he wasn't familiar with how sharp that turn was, but it was such a wide turn. I had to scoot over and back up. He came clear. His full
doesn't make sense, but
his full cab came clear into my entire lane, not just the corner of his truck.
if you had a back up 3 car lengths, you would have hit the police officer who was 1 car length behind
Oh
you.
no, he was continuously backing up behind me. He wasn't parked there.
So he backed up for 3 car lengths?
No, he was probably another 2 behind me. When he came upon me, I was backing up.
Okay. All right. It's unfortunately, he has you for 2 times in the crosswalk.
Yeah, so it's not true.
Okay.
That's just not true.
Okay. Well, unfortunately, it's a he said versus she said situation.
It is.
Yeah. Okay. All right. And so based on that information, I will find this as committed, but I will greatly mitigate this down to, so I'll find this as committed, mitigate it down to $75. You have 60 days to make this payment. If not, you can enter a payment plan. This information will be mailed to you at your address on file in Kelso.
Okay, I want to go on record as saying he's absolutely incorrect. I wasn't even near the crosswalk. That's just not true.
Okay. Well, thank you for your side of the story, ma'am. I appreciate it. Tori Majerith.
Hi.
Hello. So you did the deferral program in 2020. You are not eligible for this program. Let's go forward with your contested hearing. Let me just look over the police report really quickly, and then I'll let you tell your side of the story.
Okay.
All right, so you were in a collision based on you reached down to grab your water bottle, took your eyes off the road, and then hit the car in front of you.
So I told the officer, I think, multiple things because I don't really know what happened. And I'm being completely honest. I don't know. I just remember all of a sudden this car was in front of me and their brake lights were on and I hit them. I have no witnesses. I haven't looked at the police report. I had 5 broken ribs and was not in the right state of mind at all. And the police officer was talking to me and I don't know what I said. I didn't even know I told him that. So I don't know. Like, I honestly don't know how it happened. I don't know how I hit somebody on the highway. And I know there was supposed to be a witness, but I don't have the police report. I haven't been able to look at anything, and I don't know like what's going on other than my insurance is dealing with the other person. But there was a witness that said that there was a black truck that had caused the accident that caused me to hit the other person. And I don't know if that's in the police report at all, if you see that. But I know the officer said that to me. I remember him saying it when I was in the hospital.
Yeah. So the officer's remark, the driver of the second vehicle advised she was also traveling northbound in the left lane. There was a collision further north and traffic was slowing down. The other driver stated she slowed down to accommodate for this, and you hit her because you didn't slow down.
Yeah, the thing is though, is there was nobody in front of me when I was driving, and all of a sudden she was in front of me. So I don't know if she swerved in front of me or got in front of me real quick and then slammed on her brakes, but she just all of a sudden was in front of me, and there was nobody in front of me as I was driving. And that's where I'm confused as to how it happened.
Well, I'm just telling you the other person was in front of you based on the remarks of that person. And you said that you told the officer that you reached down to grab your water bottle. And
I don't even know why I said that. I think I was just in shock and freaking out. I mean, I felt like I couldn't breathe. I literally had 5 broken ribs. I don't even know half of the things that I said to anybody in that moment. I was just completely out of it.
So, ma'am, how am I supposed to handle today? I have an officer's report with what you said the day of, and now you're saying you don't know what you said. So
Yeah, I
What
don't
is the
know.
point of this hearing?
I don't know. I don't know what, I don't know.
I'm extremely sorry for the injuries that you incurred from this, but you know, I can't really proceed with you just saying, I don't know what happened that day. That's not beneficial to a contested hearing. While I am very sympathetic to your injuries, that doesn't help your case.
So the officer wasn't there when it happened, so we're just gonna go off of what he says I said, and that's it? Is that how it goes?
No, what happened is he came to the scene and you
Correct,
said, this is
after
what
it
I did.
happened. Yeah, but
Yeah,
I
but you
said
said
so many
something that-
things. Did he write everything down that I said?
That's not my job to follow that up. What I have is a police officer's report in front of me. I have the other person who said that they slowed down and you didn't.
Yeah, they got in front of me when I was going 70 miles an hour.
Okay.
So of course I'm gonna hit
Okay.
somebody going in front of me. I don't remember reaching down for a water bottle at all. And I don't
Okay.
even remember saying that. I don't know what I said. I was not in the right state of mind.
Okay. I'm gonna go ahead and find this committed. I'm gonna mitigate it down to $115. You have 60 days to make this payment or set up a payment plan. This is gonna be mailed to your address on file in Kelso.
Okay.
All right. Thank you for your time.
Yep.
Yeah, welcome. Okay, we are here in the matter of West versus Blunson, formerly Blunson versus Blunson, case number 15-04065. DM, ma'am, this is your motion. What do you care to add to it?
Just want to add to the fact that it's been since 2015, we've been divorced.
Right?
It was 7 kids involved in the divorce, and
Yes.
he's paid $32 every 2 weeks since
Well,
then. I just feel like that is
I
not
know
right.
that you, well, so that I could explain to you, you could have asked for this to be reviewed every 3 years.
I
And
know,
you-
I just
no,
learned
yeah,
that.
yeah, no one
Yeah.
ever, no one ever asked in the file. I mean, we would prefer to leave you alone because we
Yep.
don't want to, we don't
Not
want to,
me.
yeah. But it looks like there's only one child left that's under 18.
Nope, there's 3.
There's 3. Okay.
Yep.
Okay. You have the right to ask, and it's an automatic. We will send it to the front of the court for child support. Do you have any questions, Mr. Blunson?
Yes, sir. Far as that goes, she won't let me see the kids. I can't be involved in them with them whatsoever.
Okay.
She's saying I haven't did nothing since 2015. She took that away from me. Like
Okay.
she
Then you need to, then we are here on a child support order. You need to file a motion on parenting time.
All right, well, no problem. No
Because
problem.
again, I'm assuming that since there's nothing in the file, I'm assuming you guys, everything was going smooth and you were seeing the kids and she was fine.
No,
No,
not at all.
I was working 2
Like I
jobs
said,
taking care of it.
there's nothing
That's all.
in the file that says there was any problems. The
Right.
only thing before me is a request for a child support review. And since I don't know what the past almost 10 years has been,
Okay. Well, I'll put in
I need you to put that in writing and figure out that way she may respond to it appropriately and say why it would be or would not be appropriate.
Okay, I want to say I filed that motion. I sent it to her house. I want to say I dropped it off there. I have the copies in my hand right now.
When did you set it for?
I never received the motion. I received a bunch of paperwork
I don't have anything in the court file.
Because he didn't file a motion through courts. He sent his paperwork to my home, which is harassment.
Yeah, you have to file the paperwork through court.
That's
And
harassment.
no, it's not. Filing paperwork to try and get parenting time is not
No,
harassment.
if he filed paperwork through court, through the court office, yes, they
Yeah.
sent paperwork to my home,
Okay.
not a court paper.
Well,
She sent me
again,
a bunch of letters.
hold on. A request for parenting time is not going to be considered harassment by the court.
Okay.
Okay. Just to let you know, people
That's
have the right
correct.
to ask to see their children.
That's correct, but I'm
So,
telling you, the paperwork that I received, sir,
all right,
was
what I'm
just a
going to do.
letter from his
All right,
girlfriend.
all right,
No
Mr.
papers
Blunt.
through the court.
Okay, Mr. Blunson, file your motion and we'll see you for that motion, okay?
Okay, no problem.
And ma'am, I'm going to reserve the date of starting child support as 11/1, but and I'm going to send this to the front of the court within 2 weeks, but I'm going to give him 2 weeks. If I get that motion, I'm going to combine the 2 motions because that way it can be looked at in total. Because otherwise it's two different departments. One of them does child support, one of them does parenting time and child support.
Okay.
If I only send it for child support, it goes to the one division.
Yeah, because the child support is what we're here for.
Right. And and I'm only going to give him 2 weeks because I'm not going to hold it too long, but you have a reserved date of start of the child support is November 1st, one way or the other. But then if he does file that and I do send it to the front of the court, which I will likely do, by the way. Okay, but the reason I need the motion is because I need the front of the court. Like I said, this file is pretty empty of any information. That motion should contain that motion should contain information, and you should respond in writing that contains information as well. That way we can send all that information to the front of the court so they have a starting point on working with you with that. So, sir, if you do not file that appropriately, I'm sending this just for child support. Okay.
All right, no problem, sir. Thank you.
Good luck to both of you. May see you in a couple weeks. Take care of yourselves.
Yep.
But your motion is granted, Ms. West. One way or the other, we're getting child support started on November 1st.
Thank you very much.
Okay. Yeah, it starts the first of the month after you filed it. You filed this in late October, so it'd start November no matter what. Okay?
Oh, okay, thank you.
Have a good morning to both of you. Good luck.
You too.
Look forward to seeing you again.
Yep.
All right.
Elizabeth Howison versus David Pomeranke, file number 2206784DM. This is the defendant's motion alleging a violation of the judgment of divorce. Mr. Pomeranke is present. Court calls Elizabeth Howison. A response matter scheduled for 9 a.m. It's currently 9:52. Mr. Pomeranke, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
David Michael Pomeranke.
Mr. Pomeranke, you filed this motion, correct?
Yes, sir.
And you filed it with the clerk of the court?
Yes, sir.
All right. Before we proceed on the motion, the court does not appreciate you telling court staff to shut up.
Who did I tell to shut up?
Court staff reported to me that you told court staff to shut up.
No, I did not. I did not say shut up to anyone.
Okay, well, do you need to call in the court employee to address that?
I guess if you'd like, because I didn't say anything to no one.
Okay.
I was talking to my significant other about other stuff.
Okay, stop.
I apologize, and I said I'm sorry. It slipped out. It's human nature, and I apologize.
It's not human nature as far as the court's concerned. I have to restrain from using that language. You need to as well.
Yep.
You have an understanding. Please, even though you deny it, and I'm not here because I didn't see it, I didn't hear it, but it was reported to me. If you did it, excuse me, sir. Don't do that, please. That's all I'm asking.
Yes, Your Honor.
Just be respectful. That's all I'm asking.
Yes, Your Honor.
Thank you. I appreciate it. You've alleged in your motion, Ms. Palmer and Ms. Howison is not here, the window loan, that the window loan has not been paid. Is that correct?
Yes, Your Honor.
Okay. Do you have any records or anything to indicate the same?
Yes, I gave a copy to the court's clerk office of like everything that I've got from Foundation Finance.
Okay, and that's dated January 27th, 2025?
Yes.
Okay, it's in the court record then.
Yes. Also, I have in there a copy of our judgment of divorce, and
the court reviewed that.
Yep.
Now, it appears that this has not been paid since 2021.
Correct, Your Honor. I was the last one to make a payment on it on 9/21 before I was incarcerated when she had taken over the house. And she was supposed to take over the payments. And then the judgment of divorce was ordered in 23. And that was over a year and some change ago, and she still has not made a payment. And Foundation has called me and can't get a hold of Ms. Howison. And I'm deemed indemnified and not held responsible for it, and it's ruining my credit.
What are you requesting of the court then, sir?
I talked to Foundation Finance. It says right here the payoff amount is $11,956.08. That's what they want in order to get my name off the loan. And I don't know what else to do in this matter because it says in the order she was supposed to pay it and she has not paid it.
Okay. What the court is going to do, Mr. Pomeranke, is issue a show cause for her, which means that she'll be required to come into this courtroom. She should have been here today.
Nothing's going to happen about that for her not showing up. Well, that's a contempt.
At this point in time, I need to have the information for. The show cause could be a contempt, but I have to show cause her first.
Okay, okay.
I'll show cause her. The court sua sponte on its own initiative will show cause Ms. Howison. She must appear at the next court hearing, and she could be held in contempt at that hearing.
Okay.
I can't proceed on contempt at this point until I hear from her. But in the meantime, I will require her appearance at a future hearing, which will be sooner than later.
Okay.
Any questions, sir?
No, that's it.
All right.
Good morning, Ms. Johnson. Ma'am, you were charged with assault, bodily injury. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes. Okay. The officer was dispatched to a service in Harris County, Texas. The complainant and the first witness, the complainant's mother, stated that the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and defendant were inside an apartment when the fight began. The witness stated that she observed the defendant to have a small sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain. The defendant told the officers that the complainant believed that defendant was with the complainant's ex-boyfriend, which is what started the fight.
And it's just an assault?
Yes, Judge.
Johnson, I'm going to find that there's probable cause to go forward with the case. I'm shocked that it's not an aggravated assault. Let me tell you, I'm ordering you now as a condition of your bond not to be in possession of any weapons and not to have contact with the complaining witness in this case. Do you understand? Yes or no?
Yes.
I want you to understand that I'm going to do everything in my power to protect the public and every single person in it. And if that means locking you up and putting the bond extremely high, I will do it in a heartbeat. Do you understand?
Yes.
We're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be on your way. Do not have contact with this complaining witness. Do you understand, ma'am? No more warnings. You will get no more warnings from us.
Good afternoon, Ms. Strong.
Good afternoon, Your Honor.
Good afternoon, Ms. Washington. Can you hear me?
Yes.
This is Judge Middleton. I'm here on behalf of Judge Pattison. Also here is Casey Strong from the Public Defender Group, and she's here. You got arrested on a bench warrant in this case. That's file number 231559SM. You were charged way back in June of 2023 with kicking somebody's window out, about $700 worth of damage.
They
And
didn't have to
looking through-
receive. Just a moment, Ms.
Okay.
Washington. We'll talk about the facts. Let the judge speak about the.
But if we're talking about the facts, I didn't get charged in June then.
All
Ms.
right, well, your
Washington, don't
lawyer,
say anything right now.
Oh my God, okay.
your lawyer is Paul Gibson.
Okay, that makes
And
sense.
Ms. Strong, you don't know this, but Ms. Washington does. She and I are related. She's about my first cousin twice removed. Her grandfather was my first cousin. And so I try not to handle her cases, but sometimes I'm compelled to. But this was a Judge Pattison case, and it's filled with Ms. Washington failing to appear when she was supposed to. There were, I think, 3 separate bench warrants. Then she failed to appear for sentencing, and Judge Pattison set the bond at $5,000 cash or surety. The court, I'll let you, what they said is, oh no, then you were placed on probation, and there was a
15 days time
probation.
served and 20 days time served.
Ms. Washington, we'll talk
Well, yes,
about.
you got
He's saying
20
that
days.
we're stating the facts, why can't I say the truth? And then he said I had to go to probation. He said, come check in with the probation officer until you can see if they bring me a receipt. I talked to them. They don't have a receipt. They talk to the courts. So if you want the truth, then don't Miss Washington. I'm not listening to you then. I'll stay in jail forever if I gotta
I want to
listen
hear
to you lie.
everything you have to say, but not when we're on the record. Give us a moment, okay?
All
We'll talk
At
about it.
any rate, you are correct, Ms. Washington. It was a probation violation bench warrant. And you're right, there were issues about how much the window was worth. They claimed it was worth $759. Judge Pattison ordered something less than that. He's not here today. And how did you get arrested last night?
I didn't. I got arrested this morning. I was literally walking down the street.
Okay, in Sturgis?
Yeah.
All right. Are you still at the North Centerville Road address?
Yes.
Okay, address is still correct. I'm gonna set PV arraignment for 10:30 on November 19th. Mr. Gibson is set to be there that morning. And I'll let Judge Pattison deal with this. He wasn't very happy about this, why he set the bond at $5,000 cash or surety.
You said my bond?
Yes.
How? If I got time served and the people told me that I don't have to pay anything because they don't have a receipt or evidence that I did anything.
Well, he put you on probation and
No,
then
he did
you
not.
never complied with any of the terms of probation.
Okay, so
Well,
I
you
got a $5,000 bond because I'm ready to go back and lay down. I'm not in the mood for this. I've been to court like 15 times for something I didn't fucking do, and I already got 16 days time served. I'm tired of doing this. I'm tired. I just want to go to fucking sleep. Leave me alone.
All right, you got 20 days, credit 20 days. And then there's this probation issue. So you go back and
No,
take
I
a
literally
nap.
got 16 days
Judge
time served and
Pattison will
20
see
days
you.
time served. I didn't get put on probation because I don't have anything that I have to pay.
Yes, you do. I think you have a disagreement with what Judge Pattison ordered.
No,
So
I
anyway,
don't. I literally talked to people and
take
they
a
don't have
nap.
any evidence that I broke the fucking window. They said there is no receipt. I went there 3 different times and had them fax the paper and everything. And this is so irritating. Can I go back to sleep? If I got a $5,000 bond, I'm not getting out then. So can I go back to sleep?
Yes, yes, you can.
Man, it makes no fucking sense. Open the door! Goddamn! Man. I'm not passing me that. This is so stupid. How do I get time served and then I have to open the door?
I can see why Judge Pattison set the bond at $5,000. I had to study the file. She did get 20 days, credit 20 days, and he put her on a probation. And then she failed to comply with any of the terms, failed to report, failed to pay fines and costs, failed to abstain from the use of alcohol or drugs, failed to participate in treatment, failed to maintain full-time work. She had a probation violation hearing set for October 21st, and she failed to appear. See how she's doing when he sees her on Tuesday.
Yeah, I'll send Paul an email and give him a heads up.
Is Ms. Johnson here? There she, yeah, there you are. Ma'am, you have to unmute and state your name, and then Trooper, state your name, please.
Trooper Weston Williams.
Crystal Johnson.
All right, any offer here, Trooper?
Is this for Mr. Ali?
No, it's for Crystal Johnson. This is a violation basic speed law. So she slowed off the roadway into the woods due to a snowy, wet condition.
Yeah, I'd offer impeding traffic.
Do you want to plead to impeding traffic, ma'am?
No, sir, I do not.
Okay, so I want to just have you listen to me a second here, and then we can go from there, okay? It doesn't matter. It doesn't matter to me whether you take impeding traffic or not. We have a hearing that can take place right now by Zoom. Violation of the basic speed law requires you to keep your vehicle under control at all times, no matter the road conditions. So if, as an example, I determined that you were traveling and you drove off into the off the roadway, that would be a violation of the basic speed law. I'm not trying to talk you out of having the hearing, but if we have the hearing and you lose, you're going to get the points. So but I'm not under any circumstance trying to talk you out of having a hearing.
I understand.
So do you want to have the hearing still, or do you want to plead to impeding?
I want to have the hearing.
Raise your right hands. Trooper, I need to see your hand, please. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Trooper?
Yes, sir.
Ma'am?
Yes.
Okay, you can proceed, Trooper.
I'm on a crash right now, sir. Do you mind giving me 1 second here? My partner.
No, take your time.
Real quick.
Pardon?
My partner's going to kick these occupants loose, and just give me 1 second here. I apologize.
No problem. Do you have any questions about what I said, Ms. Johnson, before we begin?
I do not.
Okay. All right, recalling Crystal Ann Johnson, 25M491844. Trooper, your name again?
Trooper Weston Williams.
Ms. Johnson, your name again?
Crystal Johnson.
I've had you both sworn in. Trooper, you can go ahead and proceed.
Yes, sir. On 2/15/2025 at approximately 10:39 in the morning, I was dispatched to a crash. It was a one vehicle crash. The driver slid off in the right ditch. It was snowy conditions that day, and I wrote her a citation for a violation of basic speed law.
And that was Ms.
South
Johnson?
75. Yes, sir. That was South 75 near Gibraltar.
Sibley.
Okay.
Or Sibley. Sorry about that.
Okay. Any questions of him, Ms. Johnson?
I have no questions, sir.
Do you wish to testify?
I do. I actually wish I could be in court right now, but obviously Trooper Williams isn't there, so it wouldn't matter. He arrived an hour after the situation, so I would like to state that. Therefore, he had no idea what the conditions were of the roads. I would like to state that I drove 34 miles without incident before sliding off the road. So clearly I was not driving erratically if I made it 34 miles in a snowstorm. I printed out pictures of what the conditions were. You can see his vehicle right there.
Ma'am,
yes.
Before we go on, I'm gonna listen to you.
Okay.
I'm not gonna be a legislator here, though. I didn't write this law, and it says what it says. And
understood,
that
sir.
that is clearly a violation of the basic speed law. I'm trying to help you. I'm not trying to hurt you. I'm not trying to cut you off. I'm not trying to be mean or any other such thing. This was a technical violation of the basic speed law. I cannot do anything but find you responsible. If you want to take the impeding, you're going to save yourself 2 points. Now,
sir,
I'm going to listen to you. I'm not going to debate it with you. I'm just trying to tell you again nicely, and then you can tell me, Judge, I want to proceed, or Judge, I want to take the plea, and I'll shut up and listen.
Okay, Judge, I am wanting to proceed.
Okay, go ahead.
Thank you.
Go ahead.
And the reason I am proceeding is because there was no speed violation whatsoever, as I made it 34 miles without any issue or incident. The officer, you're not listening, so this is great. You're as great as the trooper is. And I would like it on.
Whoa.
No, I want this on record that this is what the problem is, and this is why I did not want to take the impeding traffic. The officer mocked me. The officer made sure to belittle me. And I refuse to allow that kind of treatment.
Okay.
So that is where I'm
Anything
coming
else?
from. That would be it, sir.
I want to make sure that you've had full opportunity to tell me everything.
No, I haven't, because you have made it clear that you do not care to listen either. And it is okay. I have gone through the chain of commands that I need to, and I will continue.
I could tell you had a chip on your shoulder from the get-go. You know that?
Oh, thank you.
I'm trying to help you here, and you want to make your own. You want me to make my own laws, and that I can't do. I just asked. Hang on. I asked to see your record. That's all I said. Do not accuse me of not listening. I heard every single word you said. If there's anything else you want to say, go ahead and say it. I'm all ears. I'll listen to whatever else.
Okay, I'm going to speak now then. Is that okay?
No, it's not right now. Trooper, did you mock her in any way?
No, sir. So she filed a complaint against me to my post commander. He sent the video up to our internal affairs who investigates complaints, and they didn't find anything wrong with the interaction we had. The only thing that was wrong, I wasn't wearing my hat.
You were wearing your hat, sir.
That's what I told them, but I wasn't wearing it for the whole time. So that's what they talked to me about. I didn't get in trouble for anything else of how we interacted with each other. So,
all right, go ahead, Ms. Johnson.
So when he asked me if I was speeding, I told him I was not. And he gestured to the people driving down the road and said, well, none of these people are flying off the road. To me, that is mocking me. I had been through something traumatic, and for him to say something like that and compare me to people is absolutely sad and not okay. Period. And it went downhill from there. It's not that I have a chip on my shoulder. I showed him the utmost respect. I tried very hard to be very kind until that moment. Then I told him I did not want to speak to him anymore. And he continued to follow me. And I don't feel as though that kind of treatment, basically victim shaming people, is the way to handle yourself as an officer. I went home and had a conversation with my 21 and 16-year-old to let them know, do not call the police if you are ever in trouble. They do not care.
Gosh.
It was awful. It was a bad situation. It's not a chip on my shoulder. It's me being hurt.
All right, listen. Okay. Anything else?
That's it. Just that it was a snowy
I want you to
condition.
understand. I would never condone anybody talking to anybody in a demeaning fashion.
Well,
okay?
It was.
Well, but that doesn't entitle you to a dismissal of the case. I tried to tell you nicely. I tried to tell you 2 or 3. I mean, I don't have any choice but to find you responsible as charged.
That's fine.
I really wish you would have taken the impeding. I really do.
That's fine.
135 is your total. Can you pay that today, or do you need time?
I can pay that today.
Okay, you can go online on 33court.com.
Thank you.
Good luck to you, ma'am. I wish you well. Thank you.
Yep.
Yes, it's Saranda Smith.
Okay, sorry. Yes, she's on this case. Calling case 2023-31060 DC Saranda Smith versus Devin Daniel. Today is Monday, December 16th.
Says Miranda Smith on it.
At 11:01 a.m.
Oh, boy.
Court will note the appearance of Mr. Hilderly on behalf of the defendant. This matter is before the court on the defendant's motion for entry of the final order and the UCSO. I would note, Ms. Smith, the court has previously been informed that you did not yet pay the mediation fee. Have you paid that mediation fee?
I'm currently not working and haven't been working since I was pregnant with this little guy.
Okay.
And have not been able to work. So I don't have a way to pay anything right now on a mediation fee.
Well, what the court's going to order that you pay that mediation fee within 30 days of today's date, or the court will hold you in contempt of court. So you need to get that paid. Mr. Hilderly, you can proceed with your motion.
Thank you, Your Honor. To refresh the court's
memory, we were here before your honor on November 4th, seeking to enter this order and refer the matter to front of the court. Your honor indicated that rather than do the referral, that he asked us to prepare the calculation for child support, and indicated what he would like the plaintiff imputed at. We have completed that calculation. Unfortunately, there's a little bit of an issue with getting my client's contact or income information. He's started a new job, but we've now completed that calculation and have presented a final order, which includes uniform child support order. So it is a complete order and could be signed at this time. We're just asking the court to enter it accordingly.
Okay, thank you. Ms. Smith, you received those orders in this matter. What's your response?
I received the paperwork stating for this court date today. That's all I received. And I was figuring I could talk at this court date, and the fact that I'm still currently not working and trying to get a job since I'm having the infant. So.
Okay. Mr. Hilderly, when did you provide those orders to Ms. Smith?
Should have been included with the motion. Looks like the motion was sent out December. Looks like November 25th. Is when everything went out.
Okay, why don't we do it this way? Mr. Hilderly, what I'll do is I'll have you submit those final orders to Ms. Smith under a 7-day notice of entry. Ms. Smith, you'll get those orders. You'll have a limited time. If you have an objection to those, you're going to have to submit that objection within the 7 days, okay?
Okay. I received the orders ever.
Excuse me?
I said, if I receive the orders ever, they have fun sending orders out that I never end up receiving.
Well, that's why I'm giving you this other opportunity to get the orders. So he'll send those out to you. And then from the date you receive those, you'll have, or from the date of mailing, you'll have 7 days to object if you have a basis for objection.
Okay.
Okay. Thank you. You're free to go. Have a good day.
Thank you, Judge.
For Ms. Bailey quick.
Very good, Your Honor.
Hi.
Okay, ma'am, on the Motorola device, are you Renee Rapley?
Yes, sir. Yes, Your
You
Honor.
are. Okay, great. Let's see, I think the other party in your case is connecting. Okay. Are you Luke? Is it Vander Kirchhoff?
Vandy Kirchhoven, yes. Vandy.
Okay. All right. This is file number 2419803. The record should reflect both parties are present by Zoom video. This is set for a pretrial scheduling hearing in this divorce matter. This is a time when the court tries to determine whether or not there are any issues regarding the division of any marital assets or debts that the court needs to decide, or whether you two have been able to reach any kind of agreement. So, Mr. Vander Kirchhoff, where do you stand? Where do things stand from your standpoint in terms of dividing up assets and debts of the marriage?
All I would like is the 2007 Honda Pilot that we have. Besides that, that's all.
Sorry, you're breaking up a little bit there. Can you repeat that?
I would just like the 2007 Honda Pilot, and that is all that I would like.
All right. Is that something that you've talked to Ms. Rapley about?
We've attempted to talk about it, but nothing has been agreed upon.
Okay. Ms. Rapley, are you indicating you don't want to agree to that?
I will not agree to that. No, Your Honor, I do not agree to that.
Okay. All right. So when the parties aren't able
I
to
have
reach
never agreed to him.
Okay, that's fine.
I can't hear you. What did you just say?
I said when the parties aren't able to reach an agreement.
I don't like this Zoom.
Mr. Rapley, can you go to one spot and stay there for me?
I'm moving closer to my Wi-Fi because you're breaking up. I'm sorry.
Okay.
Sorry, you were breaking up. So both parties, they don't agree. That's where I got.
Okay. So when both parties can't agree on how to divide things up, then we go through a process called mediation. That's where the two of you will meet with a neutral third party. Neither of you are required to reach any kind of agreements, but that third party will they're trained in trying to facilitate an agreement. So they'll talk with both of you. If you can reach an agreement, that's great. And we can set it for a final hearing after that to finalize the divorce. If you're not able to reach an agreement, then I'll set it for a hearing for the court to take evidence and testimony from both of you, and then I'll make a decision about any disputed items of debt or assets. Ms. Rapley, do you have any questions about that?
No, Your Honor.
Mr. Vanderkerchop, do you have any questions?
I have no questions, just a concern about mediation. We've tried multiple times over the past 3 months to come up upon an agreement, and she's not willing to work with me on anything.
Okay, well, like I said, neither side is required to reach an agreement. The mediators are trained in trying to facilitate an agreement between the two of you, so that's different than what you've been trying to do on your own. And so that process may work, it may not work. And if it doesn't, like I said, then the court will make a decision.
Okay.
So I'm going to refer it to the community mediation. They will be in touch with both of you to set up a time that works for each of you to do the mediation. You're both required to participate in that in good faith. In other words, you have to attend and you have to at least make a good faith effort to reach an agreement. So as long as both of you does that, again, if you're not able to reach an agreement, that's fine. But you're required to participate in the process. So Ms. Rapley, you can't just decide you're not going to participate. You have to at least try, okay?
Yes, Your Honor.
Okay, so they will be contacting you to set up a date and time. You need to make sure, both of you, that you respond to community mediation when they contact you. And then I will set this for another hearing following that. And we'll go from there. I will put that into an order. You'll also both get a copy of that. And that's all I have for today. You're both free to disconnect at this time.
All right, thank you, Your Honor.
Thank you, Your Honor. Have a great day.
This is Border Patrol Agent Amaya from the Big Bend Sector, Sierra Blanca Station. I want to welcome you all today to Dolly, the very first horse born within the service in 100 years. She was born March 9th of 2025. Here she is.
Thank you guys so very much for watching. I hope you really enjoyed that one.
And I really hope you enjoyed seeing that little filly. She's only 10 days old, and that video is already a couple days old. So they've already got a girth on her, which is something most horses get a little nervous about at first. They've already got her trained for that. They've already got a blanket on her. So, I mean, she is going to be one very well-trained little filly mare when she grows up. So thank you guys so much for watching, and I'll see you next time.